Welcome everyone to this new episode of the Privacy Espresso series, a series where we delve into the latest news on privacy, data protection, but not only everything related to technologies such as AI and cybersecurity from all over the world, thanks to the members of the Privacy Rules Global Alliance. Today with me, I have Mariano Peruzzotti from the law firm Allende Brea in Argentina, because we're going to discuss about some, let's say, updates in relation to this jurisdiction. And in particular, we're going to discuss about the effect of the recently signed US-Argentina reciprocal trade agreement on cross-border data flows and data protection frameworks in general, which is why we have Mariano as a privacy and data protection expert with us. So first of all, Mariano, thanks a lot for being with us.
Hi, Alessandro. Thank you very much for having me here. It's a pleasure to be in this Privacy Espresso.
Thank you. And let's move immediately on the topic of the day. So this US-Argentina reciprocal trade agreement has been defined as a milestone for a bilateral relationship. I'd like to focus on the data protection standpoint of it. So we'd like to ask you, what are the implications for companies that are operating between the two jurisdictions, and how does this interact with the existing cross-border transfer regime?
That's a good question, and really let me explain about this trade agreement. This was signed back on February this year, and it goes way beyond just tariffs and market access. There is a whole section on digital trade and technology, and that is really where things get interesting from a data protection standpoint. So the important aspect here is that Argentina committed to recognize the United States as an adequate jurisdiction for cross-border data transfers, and that is pretty big deal, because for over 2 decades, our data protection authority, the Argentine Access to Public Information Agency, has said the opposite. I mean, the US has never been on our list of adequate jurisdictions, mostly because there is no comprehensive federal data protection law over there. On top of that, Argentina also committed to join the Global CBPR Forum and the Global CAPE, which are, two international frameworks, one for certifying companies on cross-border data flows, and the other one for cooperation between privacy regulators. Now, how does this interact with our existing regime? Today, the Argentine personal data protection law basically says that you cannot transfer personal data abroad unless the recipient country offers an adequate level of protection. If that's not the case, you must rely on a specific exception to that provision, or you must put in place adequate measures like SECs, binding corporate rules, or even you have to obtain the consent of the data subjects, which in some cases could be very complicated for companies. So if the trade agreement is fully implemented, that will change. Companies operating between both jurisdictions, I mean Argentina and the US, would be allowed to transfer data freely without any additional safeguard. So less friction, less cost, more agility in a sense. That is the upside. And I think this part is very important. We need to be cautious here. First, because the agreement is not yet in force, it still needs to be ratified by Congress, and then the parties have to exchange a notification. So, we are not there yet. And second, there is a real risk. If Argentina opens the door too wide in the sense that recognize the US an adequate jurisdiction without any condition, we could jeopardize our own adequacy decision before the European Union. I mean, the EU has been very strict on US transfers, like you can think about Schrems 1, Schrems 2 decisions, and if EU data can flow into Argentina and then straight to the US without safeguards, well, let's say that Brussels might not be too happy about that. So I think the smart move here would be a conditional approach, something similar to the EU US data privacy framework, where adequacy applies only to companies that certify under a specific framework. That way, Argentina will honor the commitment, the international commitment with the US, while we facilitate business without putting the adequacy decision at risk. So that is really where I see this going. For the time being, companies must still comply with the conditions and restrictions for the transfer to the US, but this could change in a few months.
Okay, that's very interesting, Mariano. And it's from my perspective, what I'm hearing is not sounding that new on several parts, but the closest discussion I heard to what you are giving us an explanation of, it's the UK position, meaning that the agreements between UK and US and how those were affecting the decision towards the EU was indeed a big discussion. So something that probably we see replicated here. So very much looking forward to see what are going to be the next steps of these, and which brings me to the immediate, at least to my view, connection to this, which is, where is Argentina standing with this data protection framework? Because there has been several discussion over changes in your existing data protection structure. There have been legislative initiatives. So and that's a question that is, funnily enough, I was recently discussing with our Canadian member, because they are also having some changes after a lot of trials and proposals. So where is it Argentina standing now, and how likely it is that a new law will be enacted in, let's say, the short/medium term?
Yes, you're right. This is a topic that, well, has been dragging on for years. Our data protection law turned 25 years old. So, I mean, it was really groundbreaking when it was passed back in 2000. It even got Argentina recognized as an adequate jurisdiction by the European Union in 2003, as I mentioned before. But, well, I mean, 25 years, a lot in tech time, right? So the need for an update, I think, is pretty obvious.
Yeah. In particular,
Now,
sorry to interrupt, in particular for this sector, 25 years, it's a lot, right? So you know better than everyone.
yeah, it's a lot of time. So now, if you look at the last few years, and you mentioned this, there have been several attempts to amend, modify, or update the regulations. In 2019, we have the Argentine Data Protection Authority preparing a first draft bill that was then filed by the executive branch to Congress. Then we have another initiative in 2023 that was again introduced by the executive branch in Congress, but they were not discussed by the Congress. More recently, Representative Martin Jessa came up with a different proposal, which is a bit more, I would say, more focused on innovation. And now the Ministry of Deregulation of the Argentine the executive branch is working together with Jessa's team on a new draft. So there is a real political traction behind this one, which is, I think, something new. So what we are analyzing this, in general, all the bills that have been introduced in Congress and the current one, we will see that they share a common backbone, and it's basically aligning Argentina with the GDPR. So we are talking about principles like accountability, privacy by design, privacy by default, new rights for individuals, for instance, data portability, and the right to object to automated decisions. And speaking about AI, the latest draft, the one being worked on by the ministry, actually goes a step further. It has provisions on AI, things like AI systems, the right to object to automated decisions, as I mentioned, and even incorporates regulatory sandboxes for AI projects. So now the question is, how likely is that we get to a new data law in a short term? And here I will prefer to be cautious. We have seen bills come and go, right, over the last, I would say, 10 years, but this time feels a kind of bit different because the executive branch is actively pushing it together with a legislator from the ruling coalition. So there is a real momentum here. Still, well, Congress dynamics in Argentina are, unpredictable, to say in some words, and there is still discussions on some sensitive points, especially around AI provision. So if I had to bet here, I would say the discussion will definitely move forward this year, but whether we will have a new law in the short term or not, I think that is still, a big question mark.
Thank you very much, Mariano. And among the many interesting things that you were sharing with us, one of the first one I've been that really popped up in my mind was how much there might be a connection between the second point we have been addressing today, meaning the legislative initiatives in Argentina, and the first point, meaning the trade, the reciprocal trade agreement. It sounds like there might be a good opportunity here, also because it might mean addressing two relevant topics at once, because now you have from the one side the fact that Argentina, as you were saying, is trying to stay adequate to the EU. So there has been a long storyline of trial of changes through your framework in line with that. At the same time, there is a discussion over the trade agreement with the US, which might endanger, but might also be the right time to find the right way in order to have both of them together without one excluding the other. So how do you see the combination of those two opportunities together? And we didn't touch the topic of the jurisprudence, the cases, but is there also any case law or anything that might be helping in this regard, in particular in a view where we're looking for how can these support, let's say, multinational companies with operation in Argentina?
Yes, we had I would say, a very important case decided by the Argentine Supreme Court on the possibility of sharing information between agencies, public sector, which reinforced the need of consent, which is, quite important. But in general, the courts were not very active on data protection. So having in mind these three aspects, I would say that the best recommendation for company is to stay alert. We are expecting some changes in a short period of time. So for multinationals operating in Argentina, well, this is really a moment to keep a close eye on the ground. I would say review your cross-border transfer mechanism, revisit your compliance program. Do not assume that what worked yesterday will work tomorrow, because things are moving. And I think, well, they are moving very fast, and we expect that probably the regulation will change in the coming months.
Mariano, we are running out of our time. So I just wanted to say thank you for sharing all of these and giving us this great update on Argentina. We are really looking forward to hear more and to hear about updates from Argentina, which is also a good way for me to invite you to come again very soon, and also our listeners to meet us very soon again. So thank you all for being with us, and to the next Privacy Espresso episode. Bye, Mariano, and bye, everyone.